Name, address, identifying information, and the guns that were purchased on that particular 4473 on a single page.
Yeah, we raised the alarm bell on that like 3 years ago, and nobody seemed to care. But as simple as it is, of they took all the really important stuff on the 4473 instead of it being on spread out over 2 pages. It's all on one page. It seems like that seems really innocuous, but we are the Armed Attorneys. Today we're talking about a couple of things. 4473s, where are they, and will they change if certain things are decriminalized? We're going to be talking about that. Some hypothetical scenarios with lawful purpose and what doesn't count as lawful purposes, and what happens if you block a suspected trespasser, soon to be trespasser, from entering your property. But before we begin, show your support for the Second Amendment by hitting that like button. And as a reminder, we get these questions from you folks from our comment section. It helps out a whole lot if you write out the word question and type out your question there when we're looking for these. And we really enjoy doing these segments. Edwin Walker, thank you for joining us.
Oh, it's always great to be here.
All right, I'm going to kick this first question off to you. This is from JM Delap. Question: I'm on my property and I see someone approaching who I believe intends to trespass. I yell at them, "This is private property. Stay off my property," and move to block him from entering my property. His response is to threaten me with physical violence. Am I considered the aggressor?
No, you're not the aggressor. You have a right to give people notice. In fact, obviously the Texas trespassing statute is what we're most familiar with, but this applies to almost every trespassing statute across the United States, is that an individual has to be given notice that they are in fact in danger of becoming a trespasser. So whether you choose to do that by sign, or here in Texas, we've got a very interesting one involving purple paint. Also, crops give notice, fencing gives notice, and of course, the most common form, or one of the most common forms of notice, is to actually tell somebody, hey, you're a trespasser, you're not allowed to come here. So you're just simply acting in compliance with the law. Now, if the individual chooses to get aggressive with you because of that, that's totally on them. They've now moved from being a trespasser or potential trespasser to being a trespasser plus, if you will.
Yeah, when you think about this, the way I would conceptualize trespass is someone has noticed that entry into a location is forbidden, or they refuse to depart a location after being told to leave, right? So that's what transforms this person into a trespasser. And so, typically that second one, providing individual notice, that's better evidence of a trespass, because people always say, I didn't see the sign, right? Okay. Well, what does the law generally say about a use of force against trespassers? Well, you can use force if someone is unlawfully interfering with your property, generally. And the law typically disallows the use of deadly force against a mere trespasser.
Right, against a mere trespasser. However, if that trespasser suddenly transforms himself into
dynamic situation,
an attempted burglar, somebody who's trying to assault you, engage in an aggravated assault, perhaps an aggravated sexual assault, then they are no longer a trespasser, and they are now somebody perhaps that your state does allow you to use deadly force against. Our next question comes from ES Reverse Rever 2788. I'm sure that that's probably, I know that's a word that I'm just not reading correctly. Question: if marijuana's is rescheduled to a class 3, will they remove it from question 21F of the 4473? If yes, how quickly after the new schedule goes into effect?
Well, and I'm just going to take this, if it's still controlled, this is my understanding of it. I don't know that changes the prohibition under 18 USC 922G as far as, hey, who can lawfully possess, or the section that prohibits FFLs from transferring these things. That law doesn't go away. If they mess with the drug schedule over here, that doesn't change, 922. So
I think what you would have to see is a complete legalization by
decriminalization,
every jurisdiction across the board, because there are some other things in the 4473, such as determining who is a prohibited person, that the federal government actually defers to the states. So if you're in your particular state, if this substance is still a controlled substance, then the disqualification still applies for individuals in that particular state.
And then as far as how fast would it take place? All right, let's imagine a world where completely descheduled, decriminalized, everything is hunky-dory. How long does it take the government to revise a form? It seems like it took about 6 months for them to revise the 4473 last time.
So it will, yeah. They, and especially I have found that just as a practical matter, when they're revising things that are in favor of the citizen, they seem to take a little bit
drag their feet a little
longer than things that favor the government.
All right, this one's to you, Edwin. This is Mark EK9LP. Question: incomplete discussion on the USPS question. We were discussing how to legally ship rifles and shotguns through the United States Postal Service. If you can take a firearm into a federal facility, if it is for lawful purposes, so if I'm carrying an under state law, CCW, CC, are you saying that self-defense is not considered a lawful purpose?
Well, not for purposes of saying that you are
not
accepted from the law,
unfortunately.
So yes, carrying for self-defense, that is a lawful purpose, but it's not a lawful purpose for violating the law. The purpose is your motivation for being on that property, not just your motivation in general for existing as a human being. So
it sounds very Canadian when, they're trying to get permission slips to own firearms, and self-defense they consider not a valid reason.
Right. But so you have a valid reason for carrying, you just don't have a valid reason for carrying in that particular place, because you're going into that place for a purpose. That purpose has to be a lawful purpose involving firearms. That's whenever you would find yourself in covered by that exception.
Yeah.
Our next question comes from an individual called the Ron Turner 40. I wonder if what could this man's name be? He asks, aren't the 4473 forms kept at the dealer and not at the ATF? Or is the new digital 4473 available to the ATF without going to an individual dealer? Otherwise, it would be hard for the ATF to go back and look up previous purchases from multiple locations.
Yeah, this is actually a really fascinating question. And Gun Owners of America has done some really great work on exposing the ATF against federal law, in my opinion, kind of creating a centralized database, but it's not related to these digital records from these FFLs, these gun stores. Those are stored locally, with the FFL. Now, prior to June the 25th, I wanted to get the date right, 2022, when you went to purchase a firearm from a gun store, that record had to be kept on premises with that FFL for 20 years. Well, after that, that's the Bipartisan Safer Communities Act. John Cornyn, boo this man, throw tomatoes at him. He went along and they extended that time period to be indefinitely. So if you purchased a firearm after June the 25th, 2022, technically that FFL has to hold on to that record forever. Now, what happens? Well, we saw this under the Biden administration. They would try to run these gun stores out of business. Or, these things just happen. It's a mom and pop shop, time to retire, they close up. Well, when a federal firearms licensed dealer goes out of business or ceases doing business, they go to this gun store, and if they, let's say, they weren't required to keep these records, they're turning over the records that they're required to keep, they turn those over to the ATF, those are getting centralized in a database. And so, is that thing supposed to be searchable? No. Is it searchable? I'm sure it is. But as far as those digital records, same thing applies as if it was a paper form.
And of course, we all know that the last time they revised the 4473, they moved all of the pertinent information to the front page, where all you would have to do is scan it in. You've got everything, the name, address, identifying information, and the guns that were purchased on that particular 4473 on a single page.
Yeah, we raised the alarm bell on that like 3 years ago, and nobody seemed to care. But as simple as it is, They took all the really important stuff on the 4473 instead of it being spread out over 2 pages. It's all on 1 page. It seems like that seems really innocuous, but that's all about creating a database.
Yeah, as soon as the Congress said it is against the law for the government to compile records for a gun owner database, what did the ATF do? They go, we've got to find a way to create a database.
Yeah. All right, this next one is for you, Edwin. This is Wayne Pluckett, 6920. Question: in the state of Texas, what is the definition of a person's legal residence, particularly with regards to an LTC? I'm thinking of two hypotheticals. One, someone such as a retiree who's decided to travel extensively for an indefinite period of time, but for practical reasons has no permanent habitation, and yet considers Texas as their home for other purposes such as voting, driver's license, taxes. Or the second one, someone who would be considered homeless and just lives here in Texas.
Well, your residence is the address on your driver's license.
Yeah, it's wherever
So,
you reside and intend to remain indefinitely. If you leave a state, even for an extended period of time, your residency doesn't change unless you intend it.
yes, it's so as far as purposes, here in the state of Texas, you have to have a driver's license or you have to have a Texas issued ID card. Otherwise, you really won't be able to live unless you're in a cabin in deep East Texas behind the pine curtain where nobody knows where you are living off the grid. Perhaps you can get away with it there, but otherwise, you just simply have to have an ID to exist in this world. Whatever address is on that ID, that is your residence.
And as to the second question, what if you're homeless? Unfortunately, I mean, I gotta have some kind of address, so it's either PO box, friend's house where you receive mail, shelter. There's not really a good answer to that one.
Sure. Our next question comes from an individual who calls himself Artifice MDE Omnibus 9059. And this person writes, I have a question. I've been in Austin a couple of years ago. I know, please don't crucify me. Austin is a very interesting place to be. And I've been seeing a ton of restaurants that are clearly just restaurants with 51% signs posted. So my question is this. Number one, what legal burden am I under when an establishment that very clearly does not meet the standard posts a 51%? And second, do you think there's any likelihood Texas will change the law to remove the prohibition on carrying in a 51%? Maybe strengthen the penalty for carrying while intoxicated instead? Oh, and to be clear, I do have my LTC. So, just as a point of clarification for those of you who are not familiar with Texas law or not Texas residents, one of the statutorily prohibited places is a place that receives 51% or more of its gross revenue from the sale of alcohol to be consumed on the premises.
Yeah, so that's a long way of saying bars. When the place is making most of its money for drinking on premises, all right, we're talking about bars here. Now, these signs, theoretically, big red 51% sign, this is to put folks on notice that, hey, you're entering one of these bars, this a statutorily prohibited place. Now, what happens if a place erroneously posts one of these signs? Well, it doesn't transform it into a prohibited place. If you have a location that isn't a 51% location, just erroneously post a sign, guess what? That has no legal effect whatsoever. And there's a helpful tool you can check out, the Texas Alcoholic Beverage Commission's website. They have a licensee lookup. You can search by address, name, and it will tell you in the description of the licensed location. It doesn't really give any good detail, but it'll say red or blue. Red meaning this is a 51% location. Blue means they have a license or permit to sell liquor or beer, but it's not one of these 51% locations. Now, is there an appetite to change this law? Well, actually, there was this past legislative session. We had HB 3428. This is by Tony Tinderholt, and it would provide administrative penalties to these locations that put up these signs erroneously.
Yeah, and it is, there is a nefarious practice by people who are anti-gun. Even though these individual restaurants, they thoroughly have the ability and the right to put up proper no trespassing signs. We don't allow firearms on these premises, either carried openly or concealed by license holders or by permitless carry holders. They have the ability to do that. But some of them are such cowards that they will choose to hide behind the red sign, knowing that a lot of lawful gun owners, they do not question the existence of the red sign. They don't know about the TABC website where you can look it up, or they just simply don't have the inclination to look it up. They'll just merely accept what they're fed and go on about their business. And so, yes, it does not surprise me that there are a lot of restaurants in the Austin area that are doing this. I wish there was some sort of administrative penalty, but right now your recourse is limited to contacting the TABC, the Texas Alcoholic Beverage Commission. They will send an investigator, and they will tell these people to take down their sign if they are not an authorized 51% place. But at that point, of course, you have no recourse, and you're depending upon the government administrative agency to enforce your rights. And a lot of people simply don't feel comfortable in doing that.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to leave your questions in the comment section down below. Make sure to write the word out question so we can find it for a future episode. And until next time, we're the Armed Attorneys.